Hello and welcome everyone. My name is Ann Del Castillo and I am the Senior Policy Advisor here at the Department of Cultural Affairs. I'd like to thank everyone for attending this first official event from NYC Create in Place. It's the first of 3 installments of our Legal 101 series. Before we officially kick off our program, we just want to address a few general housekeeping items. First of all, can you hear me? If you are having trouble hearing me, or if the presenters are speaking too fast or too slowly, please just shoot me a note in the chat and we'll make sure that we adjust accordingly. The automated closed captioning feature is available for those who wish to use it. Video is enabled for speakers and panelists only. Participant mics will be muted throughout the webinar and the raise hand feature will be disabled. Please submit questions through the Q&A feature. We will begin the session with opening remarks and then the presentation. After the presentation, we'll kick off the Q&A. Please do note that this event will be recorded and posted on the DCLA YouTube channel and the NYC Create in Place website. And now it is my pleasure to introduce Commissioner Cumbo of the Department of Cultural Affairs.
Good afternoon and welcome to the kickoff of our New York City Create in Place Legal 101 series. I'm Lori Cumbo, Commissioner of the New York City Department of Cultural Affairs. Thank you so much, Anne, for that introduction. For those who might not be familiar with our agency, we are the largest municipal funder of the arts, providing grants to nonprofit cultural groups. We are so proud to have launched this incredible new initiative, NYC Create in Place, to serve the broader creative community to safeguard the city's cultural and creative infrastructure. NYC Create in Place provides support to cultural nonprofit organizations and creative businesses who are at risk of losing their space or looking to expand or to acquire new space. Preaching to the choir, I know, but culture is the pillar of our city, and you all know that. The city's creative sector has a $110 billion total economic impact, generates $30 billion, let me be clear, in wages, and employs over 300,000 workers. Culture is also the backbone of the city's tourism industry, which generates $74 billion in economic impact, with more than $48 billion coming from direct spending, and that's because of you. And cultural and creative assets, you are a key element of healthy, thriving communities. Research shows on so many levels that a strong connection between cultural assets leads to better health, safety, and educational outcomes for our communities. New York wouldn't be the global creative capital that it is without the cultural and creative activity that all of you bring to our city. So again, thank you for all that you do. It's our honor to support you and to work alongside you. That's why NYC Create in Place is so important. I want to thank our partners at Volunteer Lawyers for the Arts, for presenting today's webinar on independent contractors in creative spaces. This is the first of a 3-part legal series focused on providing legal guidance for cultural organizations and creative businesses facing space as well as real estate challenges. We will provide the link to register for the next sessions in the chat. We encourage you to sign up for our newsletter at nyc.gov/culture to stay informed about future programming. Let me say that again. If you want to sign up for our newsletter, please do so at nyc.gov/culture to stay informed about future programming. Finally, I want to thank Senior Policy Advisor Ann Del Castillo, who has been leading the development of NYC Create in Place. Thank you so much, Ann, and the many members of the DCLA team who have been advising on the program. Thank you again for joining, and I'm now happy to turn it over to Katie Wagner, Executive Director of Volunteer Lawyers for the Arts, to lead the presentation. And thank you so much for your advocacy, your time, your energy, and your expertise. This wouldn't be possible without your partnership. So thank you so much.
It's my pleasure, and thank you for having us here today to kick off the legal series. We're very passionate about artists getting the legal help that they need, and also arts businesses. So we represent any arts and cultural business, or we can provide assistance to any arts or cultural business, as well as all artists, including independent contractors and freelancers. So very happy to be here today. Thank you. So I'm going to start off. I, of course, have way too many things to say and a short amount of time to say them, but I'm going to share my screen and we're going to get started here. So I think you can see it now. Yes? All right, let's get started. As a lawyer, I would be remiss not to remind you that this is a legal education program and not intended to be a substitute for legal advice. You should always seek legal advice because everyone's issues and facts are a bit different. We won't be able to speak to, and you wouldn't want your specific issues addressed here today. It's something to speak with an individual attorney about. So that said, let's get started, and I'll give you a bit of an overview of what we're going to see today or talk about. I'll first introduce you to VLA. We are very proud partners with DCLA, and we appreciate all of the support that they've given us over the years, and we are very focused. So I'll tell you a little bit about what we do. And then we're going to start with some employment basics. And I'm going to focus on this from my perspective as an executive director of an arts organization, as well as looking at it from the employee's side. These are very important issues for arts organizations, and I'll talk a little bit about what's on the horizon and why this is mattering so much to arts organizations right now. And then we'll touch a little bit on, we'll touch on the Freelance Isn't Free Act, which is a great initiative that the city led and that now has been followed by the state of New York, along with some other states, that tells arts organizations what they need to do to make sure that they are engaging with their independent contractors correctly and protecting themselves and their workers. And also talk about anti-discrimination laws and what's required of employers to provide the best workplace for their workers. So let's move to this. What is Volunteer Lawyers for the Arts? Well, we are proudly over 50 years old. We were founded in 1969 with a mission to provide arts-related legal representation to low-income artists and all nonprofit arts organizations in the city. We also provide education programming, such as this today, on issues that are relevant to all artists and arts organizations, such as copyright, setting up nonprofits, that contract drafting, transaction negotiation, incorporation, dispute resolution, runs the gamut. We provide a mediation service. We provide education and advocacy. Our goal and our focus is to make sure, as we heard the commissioner say, that our vibrant community thrives and that the arts and the arts organizations are able to sustain themselves in a meaningful way. So let me go back and just say, so we're going to start out with employment basics of, do you have an employee or do you have an independent contractor? This seems like it would be an obvious thing, but it's not, and it's actually very defined under the law. We're also going to talk about what your responsibilities are in terms of minimum wage and entitlement to overtime. It's always good to have refreshers on these things. And then talk about, again, the protections, Freelance Isn't Free Act that protects workers in the art space, as well as discrimination laws. So let's talk about what is an employee versus employment independent contractor classification. Federal and state laws govern employee relationships, and they traditionally have different rights and responsibilities depending on whether you're an employee or whether you're an independent contractor. So if you have a worker who is an independent contractor, you may not, you won't pay into unemployment insurance. You don't have to carry workers' comp insurance, but you do have to do those things for employees. Employer misclassification of an employee as an independent contractor could lead you to liability. So this is one of the issues that we're seeing recently and why we think it's so important to talk about it today. There are some basic guidelines that I'm going to talk about, that the different courts look at it, whether it's federal or state. And then I'm going to be a lawyer and drill down a little bit on some of the differences between federal and state. So some of the questions that you should ask yourself, do you have an employee or do you have an independent contractor? Well, an employee, you're going to be able to set their work schedule and you're going to have oversight over them. You're paying them a salary or an hourly rate. They are going to receive benefits, sick pay, and vacation pay, some of which is mandated under New York law. You'll be giving them a W-2 tax form. They will not be allowed to work with competitors. So you will have their time and talent, and they will be subject to company policies and procedure. I think I'll just say, for those of you who haven't freshened up your bylaws in a while or looked at your policies in a while, that's something that we do at VLA, and it's important to know because there are some requirements within the nonprofit law in New York that you have policies in place, whistleblower policies, and conflict of interest policies. So always good to get a checkup on that. So these are the things that would indicate that someone has an employee. If you're doing these things for the person, if you are a person who is receiving these benefits, has this structure, then you would likely be considered an employee. That's very different from an independent contractor. So an independent contractor, there's no set schedule. They actually should be in charge of their own schedule, telling you when they're going to be working or not working. They're paid a day rate or per contract. They generally don't have benefits, sick pay, or vacation pay. They are allowed to work for competitors. And they should, in New York State, as we'll talk about in Freelance Isn't Free Act, be bound by an employment contract. You will issue them a 1099 tax form. But just a cautionary tale. You may want to call someone an independent contractor, but you're finding that they're working in your office, they're using your equipment, you have a set schedule for them, and you're like, yes, but I'm giving them a 1099. Well, issuing a 1099 is not going to be the factor that the government is going to look at as to whether or not you have an employee or an independent contractor. So important to note that you're looking at more of the means of employment and the control over the employment. In federal court, the classification, it's an economic realities test. So they're looking at the economics of it and the extent that work is integral to the part of employer's business. So if you have someone who you've got 4 employees and one of them you're calling an independent contractor, but they come to your office and they are in charge of one whole section of your work, that would be an indicator that they are an employee. Workers' opportunity for profit and loss, if they have, if they're involved in the overall success of the organization, extent of investments of the employer versus the worker, work that requires special skills and initiative. We have lawyers here in the house. They are employees, of course. Permanency of the relationship. So if you have, if you're an employee at will, if you have no end date, that would indicate that you are an employee. Degree of control exercised or retained by employer. So again, if you can tell the person where they're going to be, what they're going to be working on, and give them overall direction, that would be an indicator for an employee classification. Now, under New York State classification tests, they're looking more at whether your worker, what kind of control over you have. Can they work at their own convenience? Again, it's back to the setting of the schedule. Are they free to engage in other employment? Do they receive any sort of fringe benefits, insurance or other vacation pay, that sort of thing? Are they on the payroll? And do you have a fixed schedule? So these are all things to look at when you're looking at this classification test. I'm not talking about copyright today, but it can have some implications too for your copyrighted works. Just put a little pin in that. If you're having someone who's working on something as an independent contractor, it has different consequences than if they are employee. So why does classification matter to arts organizations? This is something that's come up that we've seen in our office that I know that other VLAs around the country are focused on, and that is we were very active and very happy that independent contractors got access to unemployment benefits during COVID-19. However, making these claims for unemployment benefits raised the specter of employee independent contractor discussions with the NYCIF, which is the lead workers' comp insurance organization in the state, as well as with the Department of Labor. And so what happened was they saw all these unemployment claims and they said, well, you know, we should probably audit these organizations. I'm not sure that all these people, all these artists are really independent contractors. They may be more properly categorized as employees. So what is that consequence? Well, the NYCIF and Department of Labor have been auditing arts organizations, and they've been issuing fines for employee misclassification because of failure to have or to pay for an appropriate amount of workers' comp insurance, and to pay employer unemployment insurance contributions, depending. I think that the fines are smaller, perhaps, under the unemployment insurance, but it can have implications then for the workers' comp insurance. So tens of thousands of dollars in fines have been issued, and the consequence is real. Arts organizations with small operating budgets cannot pay the fines. It's causing financial hardship and sometimes closure of businesses. So this is a great concern for all of us. And, you know, with the closures, there are fewer opportunities for artists in a less vibrant art scene. So, you know, the goal of the government is, you know, to make sure that workers are protected, that workers are paid fairly. But that is a tension right now with the ability of our arts community that we all know run on small operating budgets and do a lot with a little, I will say, to create their art. So for those of you running businesses, performing arts organizations, putting on a couple performances a year, putting on art shows, you know, this is something that you need to consider and get guidance for. So this isn't something that you just need to just put up your finger and say, what is the wind blowing? Okay, I heard in this class that these are the different classifications. You know, consult with a lawyer, come to a lawyer and talk to us, and we can give you some general guidance on your issue. We can talk you through it. We can look at the cost benefit analysis. We can see what the cost to you would be and decide, you know, then you can make an informed decision. You know, that's the most important thing. At VLA, we do have individual consultations, so you can come to us regardless of your income as an individual, or as and all nonprofit arts organizations can come to us for individual consultations or to participate in our legal clinics with our law firms. And then we have longer term services for those in greater financial need. So I encourage you to get the guidance that you need on this issue. And, you know, for example, if you get a notice for an audit, they will want to see, sometimes it gets flagged if they see you have more employees than you used to have, or you've had a turnover of employees. So, you know, it's good to speak with an attorney before you have that audit. I think it can give you some comfort in that process. So other things that you need to know as an employee and as an employer, what is the current minimum wage? So federal law is much lower than New York State. Right now it's $7.25 per hour, but in New York State, the minimum hourly wage is $16.50 per hour in New York, Long Island, Westchester, $15.50 in the rest of the state. That differs from someone who receives a salary. Now, the difference between having a salary and an hourly wage is hourly workers will get overtime pay, and it should be time and a half. Salary-based employees are not necessarily entitled to overtime, but there is a limit. You have to make at least $1,161.65 a week in New York City, Long Island, and Westchester, and 1,200. Did I get that backwards? I may have gotten that backwards. I will check that. But suffice it to say, there is a minimum amount that you can, or a minimum amount to be paid to call someone a salaried employee. So if you're paying them under this amount of money, they must be an hourly employee and you must pay them overtime. And you cannot tell someone to come early, even though they're not on the clock. Any work that you are requiring of a worker must be paid. Some more things to understand. So hourly employees, as I said, are entitled to overtime when you work 40+ hours per week. Employees should receive a statement when you pay with a pay rate or overtime. And this is something that's required every year. So anytime you have a change in pay, there's a form. The New York State, New York City is wonderful about having sample forms and forms for you to fill out. So you'll go to the Department of Labor and get the pay rate form, and it'll tell you, how much you're getting paid per week and if your rate changed. And that should be done every single time that you change someone's pay. Employees are entitled to between 5 to 7 paid sick days per year. This is dependent on how large your organization is. For larger organizations, it's 7 days of paid sick leave, and for smaller organizations, 5. Most employment is at will. This is good news for, so if you're an employee, that means you can be fired at any time for any reason. Having said that, we're going to be discussing different areas of discrimination law and retaliation, and there are certain things to consider when you're considering these types of situations. Again, we have employment lawyers that work with us that we do place cases with. So if you're finding yourself in a difficult situation as an employee or an employer, again, it's something to look at. But some things to say, aside from being at will, there are a few types of employee type relationships that are not allowed. One is a trial probationary employee. You're not allowed to have someone who you're going to give a trial period to, so that's against the law. And internships, there has been a big issue over the years, and including in the arts industry, of unpaid internships. There are a number of issues that come along with that. One could look at the equitable opportunities of someone who can actually afford to take an unpaid internship. But that doesn't mean they're not allowed. Internships must serve, if they're unpaid, an educational purpose, and have more benefits of training for an intern. Otherwise, it should be a paid internship. So, those are things to look at if you're considering such a thing. Generally, interns that we have are part of law school programs that are receiving credit for their work. But you just want to look at that. There is a slightly different lens that's put on nonprofits and their interns versus for-profit employers, but something to flag. Employees cannot sign away your legal rights under law. However, you can be asked and sign an arbitration agreement. Arbitrations can serve good purposes, but they can, for employees, be quite expensive depending on what arbitration service is designated. And it does limit your rights to appeal. So while the arbitrator will be considering your legal rights during the arbitration, it will limit your ability to appeal the arbitrator's decision. So as an employee, or even as an employer, deciding whether you want to have arbitration agreements is something to consider. And employees are expected to follow the policies in the employee handbook. This is another, issue. If you think back to the control that we were talking about, you can't place any sort of expectations of policies on your independent contractors, because by their nature, by freelancers' nature, they work outside of your company. But anyone who is an employee must follow the policies in your employee handbook. Again, as I mentioned, with the reform and the update in 2014 of the nonprofit law in New York, there are certain policies that should be in place. And that's something to look at along with updates to your bylaws if you have not done that in a while. I'm just saying there are only so many hours in the day, and we know that all of our arts organizations are leanly staffed. So let's make sure that we're getting everything in order. Okay, so the city has taken the lead, I think, in the country of, I know that also, along with California and Illinois, but has taken the lead. And then back in 2019, there was a research study done on freelancers and impacts on business. You heard earlier the amounts of money that are generated, but some of the statistics, and you can look up this study, but there's a great number of workers that are engaged in freelance work. 68% of journalism or digital media workers, 67% of music and performing arts workers, 60% of marketing or advertising workers, 52% of film and television workers, 54% of publishing workers. So you're getting the idea. There's a move towards moving people towards freelance work. As an employee, again, you have to consider what this means to you. As an independent contractor, you also want to make sure that you are making sure you're protected, so and that you're getting the support that you need in your work. So there was a great need to protect freelance artists, and I will say that we see a lot of non-payment issues in the arts community. People that come into us and they haven't been paid for their work, and so we were thrilled that one of the big protections that was passed very early on in New York City, and now recently for all of New York State, is the Freelance Isn't Free Act. And that protects freelance workers from non-payment. And you're also protected from discrimination under state human rights laws and New York City human rights laws. The good news for employers, for arts organizations that are small, is New York has made it easy for you in terms of giving you a great guide, a navigation program guide for freelance workers. It includes sample agreements, complaints, and information so that you can, and it's a quite lengthy program guide that is broken down into small parts, so it's easily navigated, if you will, so that you can download a sample freelance agreement so that you can be in compliance with this law. So the New York State laws protects freelancers from underpayment, non-payment, or late payment. It protects freelancers from hiring parties who do not provide a contract or provide contract which is non-compliant with the Freelance Isn't Free Act. And in other words, it doesn't contain essential terms. We're going to talk about those terms in a minute. If you're in violation as a hiring party, an employer, the freelancer could choose to file a complaint with the Office of, I'm going to get this wrong, the Office of Labor Policy and Standards, which was set up as part of the Freelance Isn't Free Act. You can choose to file a complaint in court, or you can choose to go file a complaint with the OLPS, and then if you're unsuccessful, you could still pursue that claim in court. So there are a number of protections for workers, and there is guidance for employers and how to be in compliance with this law. So again, just the breakdown, these are the definitions within the legislation. Any individuals can qualify as freelance workers if even if you're incorporated or use a trade name. You're covered regardless of your immigration status. There are some exceptions to the freelancer law: sales representatives, attorneys, licensed medical professionals, workers hired or retained by any government agency. So those are carved out because they're seen as having their own certain status as professionals and shouldn't be covered under the Freelancers Act. A hiring party is any person, organization, or entity other than a local, state, federal, or foreign government that retains a freelance worker to provide any service for compensation. So what do you need to, what are the requirements under the Freelance Isn't Free Act? You need to have a written contract. As I said, you can download the sample contract. If you have your own contract, again, it's something that we can review for you here at BLA or another organization. Any lawyer should be able to review this agreement for you. You have to have a written contract for any agreements over $800 in any 120-day period. You must include timely payment. Hiring party must pay per the contract, and if there's no set date, within 30 days of the work's completion. Freelance Isn't Free Act also gives a freedom from retaliation. One of the big concerns of freelance workers, and it's understandable, is, well, they're just not ever going to hire me again. And so built into the Freelance Isn't Free Act is that consideration. So you can still bring a claim for retaliation if they're saying, well, if you filed against me, or if you're actually wanting me to pay you, I'm just not going to hire you again. Begging the question, if someone's not going to hire you again, that's enough, you know. You have to make sure that you're working with people and that you as an employer are a good corporate citizen. You know, you want to make sure that they represent you well and you represent them well. So I always say that contracts save friendships. You know, the first thing that can happen if you don't have a contract when you are working with, you know, a collaborator, a friend, anything in the art space, there's a lot of, you know, it's a small community. And you're going to be working with these people over and over again. So it is the right thing to do to have a written contract. They've made it easy for you to do so. And it protects you as much as it protects the workers. So everyone's protected because everyone knows what is expected of them. It gives you the right, again, to file the complaint with the OLPS. You can sue for statutory damages, or you can ask for double damages of actual damages and attorney's fees. This is big, not in the US in general. There are very few times when you can get attorney's fees paid for. So that is an incentive for employers to abide by these laws and to not want to pay double damages. Again, the court navigation services, there are people in the OLPS who can help you with navigating this practice and deciding whether or not you should pursue a claim and how you should pursue a claim. Or on the flip side, if you are being, you know, if someone is asking you something and you need some guidance, you can go there too. They can also bring pattern and practice violations. So it doesn't have to be just one individual. If they see something that's happening regularly, they can bring their own case against an employer. So you need to make sure that, again, it goes to your reputation, it goes to the way that you do business. You know, we did see, it's been some years ago now, and probably one of the instigators for this type of legislation, there were a lot of journalists who were working for particular publications and they were not getting paid, but it was all of them. And so there was a collective action that was brought. And so that would be an example, you know, if like no one's getting paid, you know, they don't pay anyone. You know, one, as an employee, question whether you're going to work with them again, but two, you know, employers know that you know, you have responsibilities to the people that work for you. I see in the chat, where can we find the sample of contract? Again, if the link here, it's on the Department of, I wanted to say cultural affairs, but
Consumer and worker
affairs.
protection. Yeah.
Consumer and worker protection affairs. I think of DCA from way back as Department of Cultural Affairs, but it is Department of Consumer Affairs. Do not get them confused. Yes, and it's you can download it from there, and it has links to all these different samples. And I think that in the chat there are a number of links. There we go, that you can find it. So just quickly, you know, I don't want to take up all our time on these things, but you know, it's a pretty straightforward process again, not only to have an agreement, but to file a complaint. Your basic facts of who hired you, what was the work you performed, what money is owed. As an employer, you should answer these claims, because even if you feel like they do not have their not in the right on their claim, if you do not respond within 20 days, then there's going to be a presumption with a no response. You're going to get a presumption against you that you in fact owe this money. So burying your head in the sand, not paying attention to it, even if you think it's not a viable claim, is not the right way to go. Address things straight head on, and you know, make sure that you are not putting yourself behind the 8 ball, if you will. So again, there are navigators within the OLPS that can help freelancers if you don't get paid, and giving you guidance. I'm going to go out on a limb and say they will also help employers. And so again, there's the damages and the rebuttable presumption. Anytime you're looking at damages as an employer, if you're looking at someone receiving damages from you, it's going to depend on your good faith, right? It's going to depend, were you participating in the process? Did you, you know, was the worker entitled to the work? You know, the court looks at certain things when they're deciding what damages to offer. And so again, be active in this process if someone comes to you with a complaint. So just, you know, a quick scenario: a fashion boutique commissions an artist to paint a mural. There's a written contract for $5,000 to pay within 30 days. So you're in compliance with that. But then the painter never receives payment. After 30 days, the artist files a complaint with the OLPS. The OLPS sends the complaint to the hiring party. The hiring party doesn't respond. They get a notice of no response in the mail, and they may now be granted a rebuttable presumption in court if she brings a lawsuit. There are limitations. So statute of limitations, for those of you who are not familiar with these terms, means you only have a certain amount of time to bring your claim. You can't sit on your claim for 5 years or 10 years. And unfortunately, sometimes we've seen this where someone's like, well, I mean, I've known about it for 15 years, but, you know, I just heard about you all, and so I want to bring a claim now. Unfortunately, that is not allowed under the law. For the OLPS to file a complaint with them, you have to do it within 2 years of an alleged violation. For court, you need to file if you do not have a written contract. So if it's a verbal contract, you have to file within 2 years of the violation. This is why it's very important to have something in writing. Filing a claim in court for non-payment, underpayment, or an act of retaliation, you have 6 years under the FIFA statute. For all other types of claims that aren't under this statute, a breach of contract is 6 years. There are also quasi-contractual claims of unjust enrichment or quantum merit. I've done the work, you accepted the work, and you haven't paid me. That's the basis of those types of claims. Then you have the six years. So keep an eye on that clock. New York State, as I said, just last year passed its own form of Freelance Isn't Free Act. It tracks the New York City Act. Freelancers, workers, or independent contractors, whether as individuals or through their own business again. You must have a written contract, $800 within a 120-day period. So this all should sound familiar. Violations including intimidation, harassment, discrimination, or retaliation are subject to a complaint that you can file with the Department of Labor or a civil action in court for damages. Again, double damages can be available to you. Injunctive relief, which injunctive relief means that they have to stop doing what they're doing. Attorney's fees and costs. Employers must ensure the correct classification. So employers, arts organizations, you can't just say, well, I just didn't know. You are tasked with understanding the employment law, understanding classification, and making sure that you are meeting the requirements. Again, for anything outside of New York City, if you want to look at a sample agreement from the state, the website or the link is here, Department of Labor, dol.ny.gov, Freelance Isn't Free Act. Very quickly, and I don't know, I think we might just stick on this slide and not go into too much more detail, but just so you know, there are various levels of employment discrimination. At the federal level, it's covered and enforced by the EEOC, Title VII of the Civil Rights Act. You cannot discriminate on the basis of race, color, religion, national origin, sex, age, sexual harassment, sexual orientation, citizenship, genetic predisposition, and for the ADEA disability. As we go into the funnel, it gets it's broader and more liberal in a protection standpoint. New York State, it covers employees, trainees, and independent contractors. It's the New York State human rights law. So it includes all the things under federal law, but it also includes marital status, prior convictions and arrests. It's enforced under the New York State Commission on Human Rights. In New York City, employees, trainees, and independent contractors as well. It's all of the above, plus gender identity, pregnancy, unemployment status, and credit history. And it's enforced by the New York City Commission on Human Rights. A few things I do want to point out under the state law, there is a salary history ban. So I don't know if you've heard about this, but in New York City, it's even broader. It does cover freelancers. Under the state, it does not cover freelancers. But you cannot ask, when you are interviewing someone, you cannot ask what their previous salary was. It is not your business. You're not allowed to ask it. It is against the law to ask. There is pay equity of people of similarly situated groups. There's also non-disclosure provisions. This is interesting because a lot of times there are NDAs that are signed when people are separating from their employment. As an employer, you cannot force someone to stay quiet anymore, or not anymore, but the employee, it's the employee's choice and independent contractor's choice whether to choose to disclose the facts and circumstances of the separation or to ask the employer to keep this information from being disclosed. So know that there are some very sensitive, this is a very sensitive area. You know, some employers may want to consider if someone's calling for a recommendation, you decide, you know, you may decide that you're saying, all we do is confirm that they were employed here and this is how long they were employed here. And this was their responsibilities without going into details of any sort of separation. Extended statute of limitations from 1 to 3 years and punitive damages. So that's the state. It gets broader again as we go to the New York City. There are additional protected classes based on caregiver and employment status, as I said. There's a Fair Chance Act. So it prohibits inquiries into the criminal history of job applicants until you've been given a conditional offer, and it sets strict limits on using credit checks in the hiring process. So if these are things that you usually do when you're working with an employee, when you're interviewing employees, or independent contractors, you should definitely change that process. Lowest standard to establish this type of discrimination. So when we talk about standards in court, the lowest standard is you just have to demonstrate that they were treated less well than others. That's a pretty low standard. And it gets increasingly more difficult as you move to the federal level. So there's a higher standard of what you must prove in court. Again, the protections, I think we've gone over all of this. I think another thing to point out, and something that New York City has wonderful training on, we use it at our organization for anyone who works with us must go through the sexual harassment training. And they have modules where you can go through and they review different scenarios and then have a sort of follow-up so that the employees understand, you know, hopefully will understand what the scenarios mean. you should provide them for an employee of 15 or more people if you work more than 80 hours in a calendar year or for at least 90 days. I think it's just best policy, best practice to do it for everyone. But that is something that you can, again, access on the New York City website. And that is it. I think I've even left a little time for questions, Anne. So
That was amazing.
look at me. I
A
flew
lot
through
of
that.
material covered in a very short period of time. We do have some questions in the chat. And just a reminder, if folks have more questions, please put them in the chat. So first question, when you were going through the criteria, like what the criteria is for an employee, there's a question, it's two related questions. One is, do all of those rubrics need to be in place for an employee, right, to constitute employee status?
That's interesting, and the answer is no. I think it's really something that you look at in totality. So they're looking at a balancing act, but I think if it's one of the more specific, I think you would look at certain things and say, well, they must be in your office from 9 to 5. That's going to be a very strong indicator that you're an employee. So I wouldn't say it's a sort of, it depends on which of those criteria you're looking at. There might be a little, gray area for some of them, but they look at the totality of the circumstances.
Okay. And then related to that, when evaluating independent contractor versus employee, are there some criteria that weigh more heavily than others? What if a teaching artist or musician has criteria that could classify them either way? You and I have worked on this in multiple scenarios.
Absolutely. And this is why, as someone who is hiring or someone who is entering, as a teaching artist, you want to understand your responsibilities. As a teaching artist, you may consider, for example, and this is a little bit off the side, but if you're an independent contractor as a teaching artist, which you likely may be, you'll have an employment agreement, but you also then are a sole practitioner unless you have an LLC, and you might need to carry insurance, general liability insurance, if you're doing a performance in a school or something like that. So, the answer is yes, it can differ from the circumstances, but they're really looking at the overall. It's particularly in New York State, it's about control. Who's controlling the process? Can you work for other people? How long are you going to be working for them? Is it a discrete project or not? But yeah, sometimes, what we've been seeing recently where traditionally you wouldn't think of someone who's hired to do a dance performance, and they're rehearsing, but they're probably teaching classes and doing all these other things. Sometimes people can look at it and say, oh, well, that they have to show up and do rehearsals and wear costumes and, do the performances. So that's control. This is an open question, one that concerns us. And its impact on the community.
Another question, can you go into more detail about what you can and can't expect for independent contractors in terms of policies, especially because harassment and retaliation can relate to them, so we need to expect that they align with any discrimination harassment policies?
So that if they have the discrimination policies in place?
I think that was in response to the slide where you were talking about, making sure that your policies are in place.
Right. So your concern, I guess the concern is that there's discrimination that's occurring from an independent contractor. And that is that maybe that is a scenario. I mean, if it's someone who's under your employment, then they're going to be covered by the policy. And honestly, that's a good question that I'd have to look into about. I think that as an independent contractor, if you don't have control over it, you wouldn't necessarily be responsible, but you'd be responsible. I think the concern would be if there's discrimination happening, the independent contractor to one of your employees, right? If there was that kind of scenario, then you would need to be protecting your employee.
Right.
Is that, I'm sorry that I'm not.
If the
Exactly.
questioner wants to clarify in the Q&A, we can revisit. Couple more questions. Does FIFA protect New York-based freelancers who contract with organizations outside of New York? And there might be a clarification, like, do you mean that there are organizations that are in New Jersey that are contracting with New York-based freelancers, or that there are outside companies coming to New York hiring freelancers?
I mean, I would say, I would say definitely if someone is coming into New York and employing someone inside New York, they should comply with our laws. If you're going outside of New York and being employed and signing an agreement under a different state's laws, then that state's laws would apply. So I think it could go one of two ways. But as I said, California now has a Freelance Isn't Free Act. Illinois has one. I believe maybe Ohio. So, you know, if you're hiring people, you're usually following the law of the state that you are engaged to do the work in. But it will depend on what's in the agreement. But certainly if New York state law, if New York City or state law applies to a contract, then they would need to comply with the laws.
Another question was, do you have any data on the success of DOL appeals, and any idea how long the appeal process is taking these days?
I do not have that information. I imagine in this world of data that is being collected. It is incredibly helpful. As I mentioned, I cited one just general overview of freelance information, but I am not aware of how the Department of Labor manages that information.
Regarding the question about policies, the questioner clarified they were asking about making sure the independent contractor is responsible for certain standards.
I think that that's something, because your relationship is governed by a contract, that you could put into the contract. So I would liken it to something along the lines of, you know, you see in the, let's say in the film industry, if someone is, you know, has some kind of arrest or bad act, or is, you know, something comes up, there are certain clauses that you must comply with to remain employed. So I think that would be best handled within the contract.
Okay, so then there is a question about if there is, in like the 3 minutes we have left, could you just touch a little bit on the copyright issue between employees and freelance? Yeah.
I love copyright. So the difference between the copyright versus, we use the same standards. So those same standards of, are you an employee, are you an independent contractor, deals with the control, how you're working, how you're being paid. But the consequence is different. So under copyright law, if you are working, if you as an arts organization hire someone as, say, a graphic designer, they're doing all your graphic work. The employer is the owner of that intellectual property. So they are considered the creator of that property, not the person who designed it. So the person who designed it doesn't have the right, the right to claim copyright on that material. It is done as part of their employment, and that it's within what they're hired to do. If you were like on the outside doing artwork, but it had nothing to do with your job, that would be different. But if it's anything that's within the scope of your employment, then the intellectual property itself, the copyright, is owned by the organization. If you are an independent contractor, you must have a written agreement in place. There are 9 different categories of work for hire. If you're familiar with that term, where you have to have a written agreement. So it has to be a commission agreement, and you have to be clear on, are they, you have to be clear as an organization that they are assigning their copyright, which means that you're, you know, they're giving the copyright to you. Generally, you'll see kind of a belt and suspenders type clause that says in these types of agreements, say it's a freelancer's agreement, say you're creating this, it's understood that all intellectual property belongs to the organization to the extent that it doesn't fall under the work for hire statutes under copyright. You will assign all rights in the intellectual property to the organization. As a creator, I would say that this is a matter of negotiation. So, and it can be industry specific. Some industries it's expected that the intellectual property stays with the organization if you're commissioned for it, and sometimes it is not. What does that mean? It gets to who gets to license and exploit it later. But at the very least, a creator should make sure that they have the right perhaps to post it on their website, in their portfolio, so that they are able to demonstrate, display their work with appropriate protections to the organization who's commissioned it.
There were a couple of follow-up questions, but I know we're at time. If folks are able to stay on for 2 more minutes, and if Katie, you'll indulge, I can. One of the follow-up questions was regarding copyright. There are a lot of designers in the theater being put in payroll for temporary work, but typically they own their intellectual property. So should they not be temporary employees in order to best hold their IPs?
So if you are an independent contractor and you are the creator, you want to make sure you have an agreement and you want to make sure that you're retaining ownership of the copyright. So you can just basically, they'll be licensing, they might get an exclusive license to the use of the work, but they won't have the work. But again, that is a negotiation with the organization you're working with. If you're saying, if the question is, should I be an employee because that will protect me more? The answer is no. If you're the hiring party, if you're the arts organization who wants the intellectual property and you're using independent contractors, you should make sure that you have an agreement with them that assigns you the rights. Did that cover the question?
I think so. And then one final one regarding the independent contractor policy question. It was, can you require an independent contractor to complete a workplace training, harassment training, or does that compromise their independent contractor status?
That's an interesting question, and I don't have a definitive answer for it. I would say that it could be probably something that you put into the agreement, like you understand that you have to comply with all New York City, New York State laws on discrimination and training. But I will look into that. If that person wants to reach out to me, I'm happy to follow up with them.
That's great. Thank you so much, Katie. Really appreciate it. Thank you for your time. Thank you, everyone, for attending today's webinar. We will be following up with the links that were shared here. And if you want to sign up for the next series, the next one is going to be on creative spaces and commercial leases next Thursday. And then the following week, it will be nonprofit incorporation and tax exemption. And I've put those links in the chat, and we will follow up with an email to everyone who registered for the webinar. Thank you so much again, and have a great week.
Thank you so much, Anne. I appreciate it.
Take care.